税务合规是基础，法律风控是底线。尤其是在欧洲严格的监管体系下，竞争法、外商投资审查、并购申报、行业准入等等，每一项都决定着企业能否安全落地、稳健经营。那么接下来要上场的这一位嘉宾，他是钱伯斯明星律师，法律500强认证的领军人物，同时他也是荷兰竞争法领域的权威专家，更是中国企业出海欧洲的法律护航者。他就是 Mavrick 律师事务所创始合伙人 Mr. Martijn van Hel。接下来，让我们有请他为大家带来欧盟投资审查与竞争法主题分享，掌声有请。
Thank you. Thank you for the very good pronunciation of my name. Thank you for that. Good afternoon, everyone. It's a pleasure to be here and to speak to such an eminent group of captains of industry and leaders of the government. So thank you for that. And a special thank you to Jackson and Frank, and of course you, Martin, and Pavel, where is he? And Kat and her wonderful team for inviting me and for organizing this wonderful conference today. So thank you for that. So in the next 20 minutes, but I will try to keep it in 50 minutes. I will, below 50 minutes even, I will speak about EU investment screening and EU competition law. So if you try to set up a business in the Netherlands or in Europe, and you want to invest, what are the EU rules you have to think about? So as we all know, the world is rapidly changing, and the European Union is trying to adapt to these changes as quick and as much as possible. But that's difficult, it's really challenging, especially because the EU exists of 27 member states. It was also in the video at the beginning of this conference, and each of them having its own government and different views on and interests. Europe is open for business, it's really open for business, but it's become aware of a couple of threats to its internal market. The first one is unfair competition from companies outside the EU. So, for example, from companies from China or the United States. The second one is foreign investment that could threaten security, technological leadership or critical supply chains. And the third one is a lack of competition within the EU market itself. So in the next couple of slides, I will discuss these developments into more detail, including an interesting case in the Netherlands that I am working on at the moment. And as Jackson and Frank is a global and leading HR company, and you are all leaders of large international companies, I thought it would be nice to also discuss an important decision of the European Commission from last year about HR cartels. So, well, I am a lawyer, so I will talk about the law, so it might be a bit theoretical for the first couple of slides. So the investment screening policy of the EU consists of two pillars behind me. So on your left, you will see the Foreign Subsidies Regulation, also called the FSR. And it was introduced in 2023 to address unfair advantages that companies receive from non-EU governments, so companies from outside of Europe, when operating inside the EU market. And the main reason the EU introduced the FSR was closing a so-called regulatory gap. Before we had the FSR in Europe, the EU had rules on state aid given by EU governments to EU companies, so inside the market. We also had antitrust and merger control rules, I will discuss that later on, to prevent monopolies. However, subsidies from non-EU governments, so from outside of the EU, were not, there was no legal framework for that. So that was largely unchecked. So companies receiving large support from foreign state, they could buy EU companies easily, they could win public contracts, or they could try to undercut competitors on the EU market, without the EU having the strong tools to investigate this. Well, on your right, you will see the foreign direct investment screening regime that was introduced 6 years ago, in 2000, to monitor and potentially restrict foreign investments that could threaten security, critical infrastructure, or strategic technologies in the EU and its member states. Before we had this regime, each EU country handled foreign investment screening differently. Some EU countries, they had a very strict regime, some had no regime, like for example in the Netherlands, and now almost every EU country has an FDI screening regime, including the Netherlands. And I will discuss both pillars a bit into more detail. So the EU screening, so the FSR, aims to prevent market distortion caused by foreign subsidies from outside of the EU. Examples include situations where a company receives cheap investment from its own government, gets tax advantages from its own government, or receives direct grants from its own government, and then uses that support to outcompete EU firms in the EU market. And the FSR gives the European Commission, that's based in Brussels, in Belgium, they give the EC the powers to review large mergers and acquisitions involving companies with foreign subsidies, investigate bids in large public procurement tenders, and it gives the European Commission the possibility to launch investigations on its own initiative if it suspects distortion of competition. There are a couple of thresholds, and they're on the slide on your left. And the thresholds are if you have a transaction in the EU and the target has a turnover of 500 million, which is quite a lot, 500 million euro, and one of the undertakings concerns received over 50 million in financial contribution from non-EU governments in 3 years before the transaction, then the European Commission has jurisdiction to investigate that transaction. If you have a public tender and the public contract is worth over 250 million euro or more, and the bidder has received 4 million euro in the previous 3 years, then also the European Commission has jurisdiction to investigate the public tender. Next to this, the European Commission has the possibility to start a so-called ex officio investigation. And that is, there's no threshold, but they think there might be a distortion of competition. They have the possibility to call in a transaction. And if a subsidy is found to distort the market, the Commission can impose remedies, block an acquisition, or prohibit a company from winning a public contract. So it's pretty severe, the penalties and the possibilities of the European Commission. But the good news, so far there have been very few transactions have been blocked under the FSR. Most cases have been cleared unconditionally or with remedies. So, on average, it is still easy to do business in Europe, but it's something you have to be aware of. Then, the Netherlands also introduced its own foreign direct investment regime in 2023. So all the member states now have a separate regime. It's similar to the Dutch system, but I will talk about the Dutch system because that's the one I'm working with and I know best. The screening is carried out by the Dutch Investment Screening Authority, the so-called BTI. It's part of the Dutch Ministry of Economic Affairs. There's also someone from the Dutch Ministry of Foreign Affairs available today. I just spoke to her, so she probably knows it even better than I do. And its purpose is to review investments that may pose national security risk, particularly in the vital infrastructure of the Netherlands. So think about the energy sector, think about ports, think about financials, think about quantum computing, think about semicon. So think about sensitive or highly sensitive technologies. And the sensitive technology are on the list on the left side. Or think about strategic research campuses, so universities that conduct strategic research. So, and the key question every time for the Dutch government is there a threat to the continuity of vital processes? Is there a risk for the integrity and the exclusivity of knowledge and information? Is it possible that knowledge or information will leak away from the Netherlands to another country? Or will it lead to an undesired strategic independence? Will we as the Netherlands become too independent from other countries? That is the test. So, the Netherlands have jurisdiction in case of, if you have a transaction, the key question is always, is there control? Is there control over a target company? And control means that you have 50% or more of the veto rights, of the voting rights, or if you have veto rights. So below 50% shareholding, you have veto rights concerning the size of influence over the strategic behavior of a company. So think about you have the approval of the business plan, the board members, etc. And that gives you a right to control a company. It's called concentration. That means that the authorities are, in general, allowed to investigate a transaction. A notification is required when an investor, when it comes to highly sensitive technology, I just mentioned it was on the list, notification is required when an investor reaches or crosses any of these voting right thresholds, or 10, 20 or 25% when it comes to highly sensitive technology. And these thresholds apply because even small shareholdings can provide access to sensitive knowledge or technology. And see again the list for very sensitive technology. And this list will be extended in the next couple of months in the Netherlands. So the list will be even longer. So if you have a transaction that it needs to be reviewed by the government, the assessment period is in general 4 to 8 weeks, which is pretty quick compared to other countries. 4 to 8 weeks, pretty quick. Especially if you have a trusted investor. So there are a lot of countries that are called so-called trusted investors, especially the investors in the EU. So then the assessment period is pretty quick. But if there are security concerns, it might take longer. It might take 8 months or even longer. And after review, the authority may decide to approve the transaction or approve it with conditions, with so-called remedies, certain security safeguards, or it can prohibit a transaction. But again, good news. So far, no transactions have been blocked, maybe just one, but most cases have been approved or approved with conditions. And this reflects the design of the Dutch regime. The Dutch government usually tries to mitigate the risks rather than prohibit the investment. So also the Netherlands is still open for business. So that was the legal theory for now. So let's discuss a case my firm and myself are working on at the moment. In November 25, the US IT company Kyndryl announced the acquisition of a Dutch cloud service provider called Solvinity. We in the Netherlands did not know Solvinity, but we did know that but we became aware of it because it is it services the DigiD app, the platform that we all use as Dutch citizens. And that caused significant security concerns in politics and in the media, because the DigiD, and we all have it on our phone, supports a critical government system. In particularly, Solvinity manages the infrastructure, the National Digital Identity System, used by millions and millions of Dutch citizens to access public services. And DigiD is used for services such as tax filing, it's used for healthcare records, and it's used also for the administrative proceedings of the government. And because Kyndryl is a US company, critics, the politicians and the media warned that US laws, such as the US Cloud Act, could theoretically require access to certain data, or even worse. Apparently there is legislation in the US that gives President Trump the possibility to actually shut down a provider in Europe if it has US roots. So with Trump, you never know. So this sparked a debate about digital sovereignty, dependence on US cloud providers, and also control of control over our own critical digital infrastructure in the Netherlands. So this transaction was required, needed review under 2 regimes. So the first one was the competition law regime. And the Dutch Competition Authority examined the deal under the merger control regime. We have a similar system that you have here in China. And it concluded that there was no concerns to competition because there were enough European providers left on the market. So there was enough competition. But the authority emphasized that concerns about sovereignty or security is not part of the competition law assessment. The second regulatory regime was the FDI screening I just explained to you. And because of Solvinity's role in digital infrastructure, the acquisition is now also examined by the Dutch Investment Screening Authority. However, it is not certain that this authority has jurisdiction, because cloud services are not on the list of sensitive technology I showed you. So we expect a decision from the authority in the next couple of weeks, maybe months. Hopefully they will clear the deal, at least for my clients, but that will probably cause an enormous uproar in the Netherlands. So, there was EU investment and FDI screening in the EU and in the Netherlands. So, to finalize my speech, I want to say something about the competition law and the developments. I will skip that because of the time. Our system in Europe is quite similar to the system that you have here in China. We have the cartel prohibition, we have the prohibition of an abuse of a dominant position, and we have merger control. But I want to talk with you about the cartel prohibition. So the cartel prohibition prohibits agreements or concerted practices, contacts between companies, different companies, so not inside the same company, but between different companies that restrict competition. So what, typical examples are price fixing, market sharing, output limitation, coordinate bid rigging, coordinating bids in tenders, or the exchange of commercially sensitive information. If you do that, you run the risk in Europe and in the Netherlands of a fine, and also in China. And the fines in the Netherlands and in Europe can be 10% of your worldwide turnover, and also managers, so the people involved, can also get a fine in some member states. Also in the Netherlands, the fine is the maximum fine is 900,000 euros. It's really, really, really high. If you breach the cartel prohibition, your agreement is null and void, and you also risk you also have the risk of damages claims. So customers that will start litigation. I already said in my introduction that I want to say something about HR cartels, because we are here, and Jackson & Frank is an HR company. So companies compete on various parameters, such as prices, services, quality, branding, and customers. But employers, be aware. The cartel rules also apply to the job market. And the reason is that companies compete with each other not only when they sell their products or services, but also when they hire staff. So you compete on customers, you compete on staff. So agreements between employers that distort competition in the job market are therefore prohibited and also subject to high fines. So prohibited agreements may relate, for instance, to salary level, salary increases, or other employment conditions. And authorities are furthermore increasingly taking action against agreements among employers not to poach one another's staff, known as no poaching agreements, or not to hire staff who apply for a job at another employer. This focus on harmful job market segments has blown over from the USA, where the job market has long been in the competition authority sites. So since a couple of years, the investigations have also increasingly been launched in Europe, and the first fine was imposed in Portugal in 2023, amounting to a fine of 11 million euro. And they're also on the radar of the Dutch Competition Authority, and it just announced that it will fine a company in the IT sector in the next couple of months. So let me finish with a recent case at EC level. In 2025, the European Commission fined Delivery and Glovo a total of 329 million for violating the cartel prohibition in the online food delivery market across the entire European Union. And the conduct occurred in the period of 2018 and 2022. That was the period that Deliveroo was trying to buy its competitor Glovo. So it slowly increased its ownership stake from a minority shareholding into full control in 2022. But in the meantime, it's made a couple of anti-competitive agreements with Glovo. So the first one was the so-called no-poach agreement. So they agreed not to hire each other's personnel, especially the white-collar staff, so the more important people, which reduce competition for labor and job mobility. And this is the first time that the EU has sanctioned such a non-poach agreement under the European competition rules. The other two conducts were the exchange of commercially sensitive information and the market allocation, which are just common breaches of competition law. So I will not talk about that. So Delivery Hero got a fine of 223 million and Glovo got a fine of 106 million, altogether 329 million. So why I'm telling this is because it's the first sanction of a so-called non-poach agreement on the EU competition law. It's a landmark precedent showing that employers can be penalized for agreements that suppress competition in the labor market. So, in short, Europe is very, very much open for business. If you want to do business in Europe, be aware of EU investment screening and EU competition law. If you want to know more about these topics, read the blogs on our website, or send us an email or give us a call. And I'm, of course, happy to answer any questions that you may have after this presentation during the round table that we have afterwards. So thank you very much for your attention.